I'm pleased to be joined today with over 200 attendees in addition to the panelists. So that's a great number. The webinar today will consist of a presentation from Bill Bordill on the four corners of a claim. We will then have a panel discussion which I will moderate, and we'll be looking at records, the legal definition of what essential construction is, what should people consider in relation to disputes, lessons learned from the first wave of the pandemic, what are SIF doing to support their members and the construction sector, and how are contractors dealing with the latest situation around COVID and the lockdown in Ireland. At the end of this session, we would welcome any questions you may have, so please put them in the Q&A / chat, and I will try and deal with as many of those as possible. The session will aiming to last about an hour. Conscious that we're busy people and the panelists are busy as well, so as I say, we'll try and deal with as many questions as we possibly can. So moving on, today I'll be joined with Bill Bordill, who is a fellow director and head of quantum at Decipher Consulting. Bill has worked extensively in the UK and Ireland, including a stint at Ardmac in the late 1990s. He's also a construction adjudicator and expert in matters of quantum, with over 35 years of experience in the construction industry. I'm also joined today on the panel with Shane Dempsey, who is Head of Communications at the Construction Industry Federation. Shane and his team are responsible for delivering communication strategies on behalf of the SIF. Shane has been heavily involved in delivering the standard operating procedures and communications around the various stages of the pandemic for the Federation. I'm also pleased to be joined with Niav O'Higgins. Niav is well known to many, leading law firm Arthur Cox, a specialist in the field of construction law, and Niav has represented many parties over a career spanning more than 25 years. Her clients have included Center Parcs, Intel and Facebook, and Niav has also advised on a number of adjudications under the 2013 Construction Contracts Act. Martin Cooney also joins us. Martin started his career in law with Niav at Arthur Cox, and Martin joined the NAMA before working with Byrne Wallace at Smythe & Son. He now runs the construction team at Byrne Wallace in Dublin and supports clients on both contentious and non-contentious matters, both in litigation and a range of alternative dispute resolution forums, including mediation, conciliation and adjudication. And finally, Mark McGreevy also joins us on the panels today. Mark is a Chief Operations Officer with CISC and is responsible for a portfolio of businesses within the group. He is also the Group Commercial Director with responsibility for the planning and execution of CISC's group-wide commercial and supply chain functions. So as you can see, we've got some great panelists and some great depth and breadth of knowledge, and I'm sure it's going to be a great session. So before the panelists' questions, I'll hand over to you, Bill, for your brief presentation on the four corners of a claim, please. Thank you.
Okay. Hello, everybody, and thank you for the introduction, Paul. I'd first of all like to contextualise the word claim, because most people see this as a dirty word. I'd probably like to change it to reclaim, because we're not actually, when you think of the word claim, people think you're trying to grab something that isn't necessarily yours. Whereas really what we're trying to do with a claim is to reclaim what previously was yours that's been taken away by some breach or some wrong activity by somebody else. So another party's wrong has caused you some form of grief, whether that's a loss of time or a loss of money, and you're making a claim to reclaim what you previously had. So it's an attempt to put you back into the position that you would have been in if that wrong had not occurred. Therefore, it's an assertion of an entitlement. So it's not a claim. A claim isn't there to grab something that's not necessarily yours. Now, I think in my world, there are two types of claim. There are informal claims, where you have an additional scope of work to undertake on a project, and there is a mechanism in the contract to value that additional scope, and therefore you make an informal claim, or what we know as a variation. That's a fairly traditional way of dealing with things. However, that additional scope of work may force the contractor to finish late. He may be delayed. Therefore, he may have some prolongation costs. His prelims might be spent over a longer period or prolonged. So that element of his costs wouldn't be included within the informal claim or the variation, because it's not the direct works. So the contractor has to make a formal claim for loss and expense to get himself back, or to reclaim the money he's lost in undertaking the additional works. So that positions what a claim is. It's not a dirty word. It's actually just an assertion of your entitlements under the contract or under statute. So I just want to now touch on the process of making a claim. People talk about cause and effect. And I actually think you should think about effect and cause, because the effect is easier to identify than the cause. So the effect is whatever happens on your project that has happened in an unplanned way. So if you will notice through your progress reports and your programs that something is happening in a way that you didn't envisage it to happen, that is an effect of and a cause. So once you've identified the effect, it's easy then to look at what has caused that to happen in this unplanned way. So once you've done that, the very next thing you must do is seek advice, either from a construction lawyer or a dispute resolution consultant. It's really important at that stage, because you must issue a notice. And quite often in most contracts, a notice is what's referred to as a condition precedent clause, in that if there is anything wrong with the service of the notice, or it's late, it will become time barred, and it therefore will not be valid, and you will lose your claim. If your notice is not in on time and it's a condition precedent clause, you will have no entitlement to reclaim the monies that you've lost or the time that you've lost. So it's really important to get the right advice and to submit the right notice. And I call this a top tip, but what I would suggest is that you keep your notice as wide as you possibly can. So you comply with the requirements of the contract. So if the contract says you have to state the contract clause that you're claiming under, then you must state it. If it doesn't state that you have to say the clause, then don't, because that will just hem you in, it will box you in. Try and keep your notice as wide as the contract allows you to. So now we've contextualized the word claim and we've looked at the processes you go through. The next main process is the submission. Now, what does good look like in a submission? Well, we're generally claiming for additional time or additional money. So that would be an extension of time claim or a loss and expense claim for various headings of cost, being prolongation, disruption, loss of profit, prelim thickening, whatever the effects are of the losses that you've suffered. But in this submission, what you're required to do is tell a story. And this story should set out what should have happened, what actually happened, why what happened in a way that wasn't planned, and then the impact of those changes in terms of time and cost. And only at the very end do we get to the claim for whether it's additional time or additional money. So you don't start with the end point of the time or the money. You start with the story and you lead the reader to the conclusion that you want them to get to. It's very important to keep the language simple and avoid legalese. There are lots of QSs out there who see themselves as barrack room lawyers, and they try to write documents that are there to impress, but they lose the plot. It becomes a complicated story. We need to keep the story very, very simple. Unlike the notice, the submission document should be as narrow as possible. We should be as specific as we can be. And the reason here is that we can always resubmit the submission document. You only get one chance with the notice, but with the submission, you get as many chances as you need So if you make a mistake in it, it's not fatal to your cause. So the essential elements, or the four corners, let's you know, it's the framework of the jigsaw, it's the framework of your narrative. We need to think about cause, effect, entitlement, and substantiation. Now, if there's a failing in any one of those four corners or four pillars of your claim will fail. So these have to be explained and dealt with in your submission document very, very carefully. So the cause will be any acts of prevention by the other party or force majeure, possibly. The effect will be a demonstration of the cost and time impact of those causes, i.e. a causal link between cause and effect. And the entitlement will naturally flow as a remedy within the contract or in statute. This will be any clause that gives rise to damages by a breach from another party. And the substantiation will be your evidence. So substantiation, you're required to substantiate your claim on the balance of probabilities, i.e. more likely than not. So you only need to get to 51%. It's not absolute proof. And this is where the records come in. You'll all be familiar with the famous Dublin lawyer, Max Abrahamson. He became famous for his mantra of records, records, and more records. But never were his words more true than now. You need records to evidence what you're saying, what you're claiming, what you're reclaiming. So what are those records? They would be correspondence, meeting minutes, photographs, site reports, site diaries, labour allocation sheets, calculations, delay analysis. Could be handwritten notes on the back of a fag packet, anything that factually and accurately records what actually happened on the site. So we've got the picture that we need a submission that clearly tells a simple story. My advice is always to keep your narrative document as small as possible to make the reader believe that what he's got is a simple dispute to deal with, and keep your appendices and exhibits folder as large as possible. The psychology there being that there's a simple dispute with lots of evidence backing it up. So keep them in separate documents. Now that ends what I planned to say on this. But in conversation with Mark yesterday, Mark raised the issue that he's noticed that it's becoming unfashionable to make handwritten records on site, and that several people are now resorting to tablets and apps on phones. And he asked the question, is that acceptable in a claim situation? Well, my view is, yes, it is. There's nobody anywhere has prescribed what these records have to be or how they should be presented. And if your information is in a tablet or on a telephone, it's very easy to share that information. And that would be the best thing to do, because it's an absolute record of what happened on the site, a bit like a photograph. They are great records because they demonstrate what actually happened. So I've now concluded with what I was planning to say, Paul.
Thanks, Bill, and thanks for the clear analysis of the four corners of the claim. You mentioned there about the records, and I just want to touch on a couple of things. What do you think is the single most important thing that the contractor or subcontractor should do to ensure they have the right records in terms of the claim and or dispute that may arise? So what single piece of advice? Is it a dedicated individual? Is it, you know, a database? What advice would you give somebody in that regard?
I certainly think they need to keep a data store on site so that information is easily accessible later, because when claims people get involved, lots of time and money can therefore be expended in trying to find the right information. So a data store of records is good and would be a cost-effective approach. You said, what is the most important thing? Well, clearly the information, the records have to be accurate and have to be clear. But I think the golden nugget here is they need to be contemporaneous. So that means they need to have been made at the time and also shared with the other party at the time. because if you make your records after the time, after the event, people are always going to criticize them and say that you know, they're self-serving. Even if they were made at the time but not shared with anyone, people are still going to say, well, you know, we're disputing that. Whereas if that information is recorded at the time and shared with the other party at the time and not refuted at the time, it's very difficult for them 2 years later to refute that record and say that it's not accurate. So most tribunals will take contemporaneous records as being possibly, along with a witness statement, as being the strongest form of evidence. And it's evidence. All tribunals make their decisions based on evidence. It almost doesn't matter what you say in the story, as long as your evidence backs it up, but it's your evidence that they will base their decisions on.
Okay, thanks, Bill. And just touching on the digital technology bit, this is possibly one for you, Martin, and Niamh, from a lawyer's perspective. Are you seeing any issues around digital technology and the considerations when they're being brought into the courts, and how are tribunals dealing with these innovations, and any recommendations you might have to the parties that are trying to bring or use digital technology to support their claims? So Niamh, I'll start with you if you've got any thoughts on that, please.
Yeah, well, I suppose, you know, digital technology and sort of different ways of recording, so exactly along the lines of what Bill is talking about, sort of the contemporaneous record. I mean, from the tribunal's perspective, provided, you know, it can be verified as being a true record of what happened, the use of photographs, for example, which, you know, are typically time and date recorded, are a very, very valuable means of, you know, evidencing certain things that were happening on the ground during the course of a construction project. So absolutely, we see that. We've seen that for, you know, for a long period, but increasingly, because they become a simpler way of reflecting what's actually happening on the ground, I think they are used. And also sort of, you know, other kind of digital software that's used, for example, design development through BIM and other software, you know, that again is, you know, can be tracked from a time perspective. So it's actually, you know, in a way it makes it easier to can actually see what was happening at any particular point in time.
Super. Thanks, Niamh. Martin, do you have anything to add to that?
Yeah, I agree with Niamh. I think the integrity of the technology is the key point. So can you show, like you would with a chain of evidence, can you show the integrity from when it was created to when it ended? So that'll demonstrate its reliability. We are seeing, I suppose, unique developments as technology go along. So for example, proving attendance on site is becoming easier through the use of biometric entry systems. So you can look and very quickly see, did someone fingerprint it in or out on any given day. I think I was saying on a discussion with you guys earlier, I've seen the use of infrared and thermal imaging technology to demonstrate disruption, where you could see the heat signatures on the site and see how congested it was, where a photograph might have been impeded. Also the use of stop-go imaging and cameras on sites, where you can track, you know, in a very quick method, the either congestion or developments and so on. So all of that, and you know, drone imaging as well is another one, where people are throwing drones up in the air and flying them over the site, and ostensibly it's for Twitter and Facebook and whatever else you want to put up about the job, but it's actually a really good way of tracking development and site conditions as it goes along. So yeah, they're of massive assistance, and I'd agree with Niamh. They've been around a while. It's just different methods are advancing and how you can use them then.
Thanks, Martin. And Mark, from a contractor's perspective, have you invested heavily in technology to support your record keeping within your business?
Yes, is a simple answer to that, Paul. We absolutely have over the last number of years, like many construction businesses, and are reaping the rewards from it without question. I suppose the challenge now is, when you bring this back to a claim situation, it's fantastic the records you can capture with respect to a traditional claim that happens on site, and record maybe the aspect of the work that has changed, or indeed maybe some of the disruption that's happened around that piece of work on your site. The challenge for the industry now in a COVID situation is the impact and the consequences of a COVID claim are far wide-ranging. they're actually not just site related. It's not just a production issue on site. It actually goes as far as the consequences with respect to getting resources to site. So we are seeing examples as we come out from Christmas start of this year, and we headed into a second lockdown. The major issues with regards to getting people repatriated from their home countries in Eastern Europe back to work on sites here. So how do you record the impact of all of that? It's just, so what records are going to support the impact and the massive impact that has on projects? So what we ended up having, as we just started before the lockdown, we got on site, all of a sudden people weren't arriving on site. So we were scrambling around to get, or subcontractors scrambling around to get resources from other places to make up for the shortfalls. How do you capture that effect that was happening? So you start to think about this. This has wide-ranging issues, and then you add in just to really spice up this discussion, the post-Brexit piece, right? And you've products that are delayed at ports. So you have people, products, COVIDs, new lockdowns, and now you've got not just you have projects that were fully locked down last time are now deemed essential. Sorry, that were open last time now are deemed non-essential, and vice versa, and all of that. It is, and recording all of that and that impact, really tough, really tough.
Absolutely. Thanks for that insight, Mark. That's really, really good. Niamh, just moving on to the restrictions that have been put in place within Ireland and around the definition of the word essential construction. What are your thoughts in terms of, do you think that the word essential is clear, or is there an ambiguity, or could there be construed as an ambiguity of the word essential? Welcome your thoughts on that, please.
Well, I suppose, and I love the vernacular that's coming in terms of first shutdown and second shutdown, and it's because I have folders that are called exactly that, and I think what's happened this time in terms of the government mandated shutdown of construction sites from the end of the first week in January is that they have actually been a lot clearer in terms of trying to define which construction projects are permitted to proceed. And they've tried also to take a pragmatic approach. So there are certain, in terms of defining what is essential, they've identified certain housing projects, those social and affordable housing projects that are ongoing and that were due to be completed by the end of February are permitted to proceed. And other housing projects, sort of not necessarily social and affordable, similarly, if they were due to be completed by the end of this month, have been permitted to proceed. I mean, there are obviously also identified kind of key services that just need to continue. So, critical transport and particularly utilities infrastructure. So keeping, our water and wastewater, our electricity, all of that, keeping that running, including projects for the continuing, the generation of electricity and power, and those types of projects are kind of identified as essential. There are also sort of, services that are critical to continuing, key supplies, sort of medical and pharma, products and those types of issues. But I suppose where the grey lines come are potentially around, is a service, sort of critical to supporting a key service that has been identified elsewhere. There will be some grey lines there. They have also identified sort of the provision of, plumbing and, roofing and electricity services on an emergency call out basis. So, how critical is it that certain services are carried out? So there will inevitably be some grey lines. But I think on the main, there's been sort of a significant attempt to be much clearer in terms of what can proceed. And also what we found is, a lot of the government departments and also kind of local authorities have been helpful in terms of trying to kind of tease out, is this, permitted works or essential works that can proceed or not? Ultimately, however, it's going to be a decision that the client makes. So the employer, the developer, is called upon to make the decision as to whether they think their project falls within the accepted essential projects that are permitted to proceed. And where you may find some issues is where perhaps an employer makes a call that, a service is is not within the category that can proceed, which then has a knock-on effect on the project, which then has a knock-on effect potentially in terms of claims that or sort of that may be advanced by the contractor coming through. So I think what we have now is much clearer than it was the first time around. But I think, you know, absolutely there will always be some grey areas as to where exactly a particular project falls in that.
Thank you, Niamh. And Martin, just staying on the legal side of things, what do you think people should consider in relation to their disputes and claims, and what options might they have? I'm thinking in particular, obviously, the adjudication and whether that might be helpful. So I welcome your thoughts, please, Martin.
Yeah, I suppose just going back to and echo what Bill said, probably the two key words I would say to people is preparation and communication. So from preparation, what I mean by that is having your claim ready in terms of having it in the form that the contract requires, referencing what is required under the contract in terms of clauses, or as Bill pointed out, don't mention clauses and tie yourself up in knots if they're not required. Do you have the evidence to support your claims? So often delay, prolongation claims, disruption claims are just lashed in saying you delayed me 50 days, but with no delay analysis, no attempt to link the impacts to a program. So putting in the evidence like that, as we've discussed, photographs and so on. We generally get into our jobs to carry out the substantive task, which is in construction, building something or delivering something. We don't want to be putting folders of documents together unless you're a little bit sad and become a lawyer like us. But that is where the money is. That is where the claim is going to live and die at the first instance. The better you prepare it, the easier it is for a client to assess, the easier it is for the client to determine whether there's a risk attached with the claim in terms of fighting it or going forward. And if they ultimately rejected it, you have a massive amount of groundwork done for your dispute. You have all of the stuff there at the outset instead of scrambling for it at the end. So preparation is key. We don't like it. We tend to shy away from it. We try and do the minimum. We lash in notices left, right, and center. But I would say there's more money in putting a bit of prep there than paying a lot of money to claims consultants and lawyers later on. In terms of communication, I always find it's a little bit of I suppose a paradox, or a little bit of ironic that we start a dispute where the claim to go through a very long and protracted dispute resolution process to end up talking to each other anyway about settling the claim maybe a year later or 2 years later, and after having spent a fortune. So can we look at ways of talking to each other now without having to spend a fortune and a year or two later and your cash flow impacted? So can you consider a constructive engagement, leaving aside emotion, leaving aside all of the anger that may come with not being paid, and can you engage in a discussion now? If it's not possible to do that without without being facilitated by someone else, well, can you bring in an independent third party and use a mediation to do so? There seems to be a general reluctance to use mediation in commercial disputes, because there's a general view that conciliation is better and that it doesn't work. But if you set it up right, use the right mediator, and you engage properly, it can work. We obviously have conciliation as an option. And I think really overlooked is expert determination. Really quick, succinct, concise way of dealing with niche issues. Bring in an expert, get them to give a view on it. You can set up the process. You can determine whether it's binding in the interim, or non-binding, and really, really useful to get over key issues. Adjudication has been good for the industry in terms of pressurizing people to make payment where they may have been obfuscating or obstructing the process. A couple of issues that have come to light with it is one, we've seen 2 cases this year that have confirmed that adjudication may be judicially reviewable, where, depending on the actions of the adjudicator, and depending on the actions of the appointing body, and depending on whether or not there's jurisdiction for the dispute, because judicial review relates to the review of the actions of someone exercising public authority or public legislation or implementing public policy. You're judicially reviewing the chair of the panel or the adjudicator as in exercising the statutory function. So to bear in mind, it's the court's review of their process. So that might be an option. Where that comes in, we've seen in 2 cases in the last year that the courts granted a stay on the adjudication proceedings. So they said, look, the adjudications cannot proceed while we're considering whether or not the appointment was appropriate, whether or not there was jurisdiction here. So that blows your adjudication out of the water. And both of those cases, one was issued in around May last year. That's adjourned now till February on my search of the High Court this morning. And the other one, which was before Christmas, there was an application to lift the stay, which wasn't successful. That's not going to be heard till February either. It's listed again. So that blows your adjudication out of the water. Secondly, enforcement. The courts just don't understand it. The rules and terms of enforcement indicate that any enforcement proceedings should be listed within 4 weeks of issuing your originating motion. I issued enforcement proceedings last July. They're being heard next Tuesday. So, and the payment claim was December 2019. The adjudicator's decision was April 2020. We're now into the end of January 2021. No payments made, no decision of the court, and the court won't make a decision for months. I know they'll reserve the decision. So if you're careful in your appointments, or if you're careful around the jurisdiction, you might get around it, but you have to be aware it's not, I don't think it's going to be as successful in Ireland as in the UK, because the legislation just undermined it from the outset. So that's just some thoughts on that.
That's great. Thanks, Martin. Really, really detailed there and very useful information. Shane, you thought we might have forgotten about you, but so we're going to move on to you now. So obviously COVID continues to have an impact on firms and the supply chain in the construction sector. The Construction Leadership Council here in the UK has provided guidance to the industry around contractual arrangements. But can you tell me what CIF have been doing around supporting their members, but also what CIF's view is in terms of what a reasonable and fair behaviour might be with regards to contractual arrangements? So just welcome your views on that, please, Shane.
Yeah. Thanks, Paul. Yeah, look, it's been a very hectic period. I think over Christmas, I think most people in the industry realised that there would be pressure in the new year to lock down construction. But I was personally in a state of denial that they do it right up until January 4th, the Cabinet Subcommittee. I was getting all the leaks from journalists, and for once in my life I was saying, no, that can't be right. The government wouldn't leak that. But as it turns out, they were angling towards, obviously, the lockdown due to the national figures in relation to the daily rates. And they are now looking at, and we are looking at, and our reopening, which is on the front of everyone's mind, I'm sure, is contingent on figures, not the daily rate, but the figures in hospital and ICU. And that's the figure that has to come down before we feel NPHET will, and the health authorities will, give the government the informal go-ahead to reopen the industry. So that's just to get that out of the way, because people will be thinking about that. So from last year's, the first lockdown, as Niamh has coined it, we've been advising members through our tendering and contracting department, who are always on call and very busy at the moment for members. We've been advising them to be aware another lockdown may occur at some point, and to have suitable clauses in their dealings, particularly on new projects. So we've been working on that with companies and just dealing with them one-to-one as we try and work through whether a project is deemed essential or not. Our initial advice, and we are sticking to it, is that you must determine from your client whether the project is essential. So I'll just take up a little piece of nomenclature, which all construction is essential, right? What's been deemed here, or how they're deciding on exemptions, is construction on essential projects as they define them. So I wouldn't feel like I was representing the CIF or the industry if I didn't say that we're all essential. But as Niamh has said as well, and Martin, I know there's enough grey area within those exemptions for Niamh and Martin to operate in the coming months, and we're trying to obviously guide our members as to how to deal with that. The reports from around the country are there is a fairly chunky amount of activity going on the ground between all the exemptions that Niamh and Martin have talked about there. We've been insisting and supporting the members in providing them with the latest up-to-date safety standard operating protocol, which was mentioned earlier on. So, you know, immediately when you think, oh, there's less projects on, you know, you might get a sense where people will go, I better concentrate on project X or work where I'm allowed to. But we've been, you know, reiterating strongly that standard operating procedure is still in situ, the paramount consideration above claims, above time, delays, productivity, everything else is safety. Because if the current cohort companies that can work don't adhere to the safety protocol, then the industry will face a much longer lockdown. And I think some of the issues we're talking about here will become much more extant and much more pressing on the industry and more widespread. So we've been kind of, I suppose, putting moral pressure on the companies who need very little direction from us, in fairness, to operate as strictly to the new standard operating procedure. I think version 7 is coming out in the coming days. And just, I suppose, to reiterate, we were shut down, surprisingly, I have to admit, on January 4th or 5th, not on the basis of our safety record, which everyone agrees is absolutely impeccable. We were shut down on the basis of mobility of people around the country, and they were concerned about schools, which would have involved reopening, would have involved around 1 million people circulating around the economy. And then our construction workers, they say 200,000, there's probably 80,000 on site at any one time, you know, so they were concerned about that flow of people. But like, when we look back over the HSE's figures in terms of clusters on construction sites, so that's 2 cases that are associated with each other, where one person was on the site and they infected another person. At the last count, up to January 14th, there was two cases in the whole of the industry. Previous to that, at the previous peak in October 28th, I think it was, there was 26 cases. Now, this is 26 cases out of 80,000 workers on site and 150,000 people in the industry. So the sites are safe. There are people who work in construction who have COVID, of course, but they're largely, in the vast majority, staying at home. So we've successfully prevented the importation of the high levels of COVID in the community that we saw at Christmas onto construction sites. So we really have to, I suppose, make the case to government that we're, number one, we're safe, which I think they understand. Number two, it's nearly safer to have construction sites open, because between all our standard operating procedure and our protocol and our turning people away from gates and telling people to stay away from sites if they have symptoms, we're actually, through testing figures, we're catching, you know, 1 person out of 200 tested that are asymptomatic. And we know there's much more than that in the community. So we're between telling people to stay at home and the testing that's going on, we're making a huge impact on preventing clusters on the site, but also to spread that into the community. So that's I'm practicing my argument to talk to the government in the next couple of days to say, reopen us on February the 1st. We are ready, and we are able to do that. And I know everyone on the call will be joining me in that. But so that's kind of very loosely what we're doing. The main thing we have been doing is the direct one-to-one support from our tendering and contracting department, which are, as you can imagine, 24/7. But it's really communicating the types of information that Martin and Niamh are talking about there on our daily kind of all-member circular, and advising strongly companies not to work unless the client can prove that their project is essential, albeit that the construction company is essential, as all construction is essential.
Thanks, Shane. That's been really useful. Just moving on, in terms of notifications and claims under COVID, and this is probably one for you, Mark, and I'd also welcome Niav's view, I guess, from a lawyer's perspective. So, Mark, are you seeing an increase in the notifications for COVID on the sites that you're working on, but also from your supply chain, but also in terms of, I guess, in lockdown number one, there was a general acceptance that the parties should work collaboratively to try and settle amicably their differences. So what are you seeing, Mark, from at the coalface? And Niamh, what are you advising your clients when they get themselves in these situations? So Mark, I'll start with you, please, first. Yeah.
So probably from, there is definitely a differentiation between lockdown 1 and lockdown 2. Lockdown 1 was very much, we are, for the most part, all parties involved in the contract taking a view that, look, we're in this together. How can we solve this problem and share some of the pain between us all and move on, hoping that that'll be the end of it. And for the most part, that solved most issues. Without reliance on contentious dispute resolution processes or the likes. Lockdown 2, unfortunately, my fear is it's going to be quite different. And whilst we're only early days in terms of going into lockdown 2, it's hard to see what the trends will be with respect to notifications and how much more contractual parties will get. My sense is that it definitely will be different. People are, I suppose, aware that whatever chance certain stakeholders had to share the pain, and let's look at this from the point of view of maybe a client and contractor point of view, that pot of money or that reserve that they had to try and share the pain has been used up in lockdown 1. So there is no second reserve. And that's going to start causing that tension between the parties. And I think will rely very much, parties will now start resorting to the contract in many extents to protect their interests, knowing that there's another potential dispute on the horizon over cost. And therefore, people, I believe we are going to start to see notices being issued. The correct thing, and we shouldn't apologize for it. The correct thing anybody should be doing is, in number one, protect your position. Someone mentioned earlier dialogue, and dialogue can start with a very simple notice saying to your client, I've been affected by this. This COVID has affected me. Then start the dialogue and share the consequences of that. Keep them informed as to what that looks like, and be straight about it. Be open, honest, straight about the impact that has on your business. And I think that is the best way to, one, protect your business, and two, hopefully allow a second conversation to happen that will allow us resolve the issue and share the pain in some manner going forward. But notices will be important.
Thanks, Mark. Niamh, have you got anything to add?
Well, I was just going to say, I mean, I think I agree. Like, I think it's as much like everyone has borne the brunt of this last year in terms of the impact of COVID on the ability for construction projects to proceed. And yes, there is less reserve in the tank to deal with that. I think, just to add to what Mark is saying, I think where particularly it's going to get more contractual is where parties have, given the sort of, what happened before, parties entering into new contracts have, in fact, and Shane was alluding to this fact that the supporting, contractors, but also on the employer side, to try and build in express provisions to deal exactly with this situation. Because more than anything else, certainty really helps minimize claims and disputes. If parties have agreed up front, okay, we can see this might happen again, let's agree now how it'll kind of play out. I think, that is where, there will be entitlements that have been built into contracts, and hopefully they will play out. And hopefully the drafting will stand up. This is kind of where us lawyers kind of all get a little bit, hot under the collar, because we've put together these documents and now actually they are being kind of played out in terms of what will happen. But I think the claims will happen. Hopefully there will be a mechanism now that can deal more clearly with the issue. But if there isn't, I think that is particularly where those claims may ultimately turn into disputes, simply because people can't carry this. On either side of the fence, there's much more pressure.
Thanks, Niamh. And so just moving that on then. So for those claims that have been rejected for COVID, I guess, Martin, I welcome your view, and Bill's as well, from a claims consultant's perspective. What are we seeing is happening to those? Are they moving on to formal dispute resolution, or are they just being parked until practical completion of the project and then it gets rolled up into a negotiation? What are you seeing? Martin, to you first, please.
Yeah, practically speaking, what I saw from going back to the term, the first shutdown, actually the first shutdown, I saw an awful lot of cooperation. So the parties cooperated an awful lot, and it was mitigated to a large extent by, what you had in a shutdown was your standing prelims, and the government was supporting workers through subsidizing them, through the support scheme and so on. So costs were mitigated to an extent, and the parties worked together. So I actually didn't see any disputes in the first shutdown in respect of those elements. Where I did see things becoming a little bit hot and heavy after that was, number one, the new health and safety measures to be implemented on site in terms of COVID, and number two, the impacts of COVID, flowing on from that in terms of what Mark had said, like the stuff like I had examples of subcontractors refusing to come onto site because another operative in another subcontractor had tested positive. So then all of the other packages were just refusing to come onto site, and how do you deal with that? But again, there was a really cooperative approach I saw in general taken to it, and agreements were generally reached. And I saw less adjudications this year than I did last year. I had far more adjudications last year. And any disputes I've seen are to do with traditional disputes of delay, disruption, but not necessarily relating to COVID. I think going in line with what Mark has said and Niamh is saying, I think it's going to be very different this time around. The approach from what I'm seeing has completely changed. Patience has run out, resources have run out. We've anticipated that this happening again. And I think we're going to see the claims come after the second shutdown as opposed to the first one. Now, maybe others have seen more disputes coming out of it, but I haven't seen the disputes out of the first shutdown that I probably expected. And I think we'll see it after this one.
Okay. Thanks, Martin.
So yeah, I think I tend to agree with what Martin's saying there. We've not seen the magnitude of disputes that we anticipated, but I anticipate those even more now. I think with lockdown one, as Niamh called it, there was, I was going to say a novelty value. I think there was more empathy then, and there was a lot of talk of collaboration. And we've seen instances with end user clients taking a very collaborative approach. And we've even got an instance where there's a COVID claim that also includes some other aspects, and they're taking a contractual approach on part of the claim and a very sympathetic approach to the COVID element of the claim. But that gives the contractor a difficulty there, because he's got to separate his different causes and different effects into the different entitlements and claims that he might have. And sometimes that can be very difficult and dependent upon the records that you've kept. And one of the questions Mark posed earlier was, what records should we keep in this situation with COVID, with people that we can't bring into the country that we were using on the site and materials that we can't now access? Well, nobody really knows the answer to that at this stage whilst we're in the eye of the storm. But the advice is your records need to record accurately and factually what happened, because that's what the basis of any. We've got time in the future to look at the entitlement and where you might have a claim and the merits of that. But what anybody will need is a factual account of what happened. So it's recording the facts, whatever those might be, is the important thing. And I do think that this is getting a bit long in the tooth for everybody now. And I do think that end user clients are going to become more contractual. I think main contractors with subcontractors are going to become more contractual. I think that's just the inevitable consequence of the time that this has gone on for.
Okay, thanks, Bill. Niamh, this is one for probably you and Shane, actually. From the first wave of COVID, I understand that the contracting parties sought to negotiate bespoke COVID clauses within their contracts, with a view to managing and apportioning the risks for delays and construction cost increases. Are you seeing that those bespoke clauses have been successful? And what should parties look out for? So Niamh, from a legal perspective, what thoughts do you have on that, please?
Yeah, I think in the main, it's sort of clauses that are drafted in. So typically, sort of what we've seen in terms of the types of clauses that have been negotiated is firstly dealing with time. So making sure, because the difficulty with contracts that have been entered into since the first shutdown are that force majeure clauses that might have helped for pre-existing contracts generally won't help going forward unless you specifically provide for COVID as a force majeure event. So what typically what we've seen is kind of provisions built into the delay clauses. We've typically seen a sort of a confirmation from the contractor that they have made allowance for compliance with all the standard operating procedures, the new health and safety requirements, in kind of determining their price and program, so that at the outset, in terms of the known knowns, in terms of the impact of COVID, that has been built into the contract. But then dealing with the current situation, so time, and then in some instances, what's been negotiated in is sort of a sharing of the costs associated with that. And that is a pragmatic way to go forward, because both parties know then with certainty, if there is a site shutdown, the contractor will be entitled to maybe 50% of their premiums, or a percentage of their premiums, or something that there is a clear sharing. And in the main, they seem to be holding up in terms of, I mean, it's early days in the sense that we are still in the midst of the impact of all of this. So, ultimately, the sort of whether or not they hold up and whether or not people try to find ways around them will depend on what the actual pain is that the party feels and whether they can carry that in the event. I think that's really what's going to drive, will the clauses kind of work their way through and operate to give the parties the redress that they need.
Okay, thanks, Niamh. And then Shane, from the CIF's perspective, are you seeing that the parties are, working collaboratively to embed these bespoke clauses, or is there resistance to do so?
Yeah, well, I wouldn't have much more to add than Niamh has given there in terms of, the specific details. But I think, yeah, the first time around, it was so ambiguous. And so it was a whacker, is it, or a totally unexpected event. There was no framework to deal with it. So everyone was, in a way, as Mark was saying, collaborating as much as possible. Now, there was, as you can imagine, very difficult conversations between contractors and clients on the public and private sector, and there's still some residual work to be done on the public sector side. This time around, ironically, the SI under which the government the government lockdown was mandated, it may provide a more legalistic framework for people to discuss these kind of clauses and contracts. But I think the key point is that it's too early to tell at the moment, really, because if it's a 3-week lockdown, I think, mostly people will get on with it and it'll work itself out in the wash. If it's a 6-week one, people might, the strength of those clauses might be tested, and Niamh and Martin might be getting a good bonus by the end of the year and so on, that's why we're absolutely focused on the 3-week lockdown for everybody's sake,
Thanks, Shane. And just sticking with yourself, Shane, I read yesterday that the UK government has developed a task force made up of some construction industry leaders here to build what they call Build Back Better. Do the Irish government have any plans to do something similar, do you know?
Oh, we have as many acronyms and reports and strategies as the UK do, I assure you. Nothing was as alliterative as that one, though. There isn't a task force specifically devoted to, we'd say, post-COVID, getting the industry back up and running. That is in essence our housing strategy, which has been relaunched with a housing commission in the coming weeks, and our national development programme, which is about 120 billion worth of infrastructure, and our national planning framework project Ireland 2040. So those three strategies are all hugely the essential construction industry contingent. So that's all been managed by and fed into by ourselves, the engineers, the quantity surveyors, all the relevant government departments within this nexus body between the state and the industry called the Construction Sector Group. So we're all operating off a report on the Building Innovation Framework. So look, let's see how many acronyms and reports we have as well. But I think for the first time since maybe the collapse of the economy in 2007, we've a shared kind of industry and government approach to dealing with some of these problems. Now, there's lots of work to go on and lots of areas to work on. And when COVID happens, it really puts the relationship between the state and the industry, you know, under severe pressure. But there's a good structure there, I think, for the first time in a decade or so, to bring the industry along and to really, I suppose, push and we mentioned it briefly in terms of note taking on site and so on, really push the digital innovation agenda, and that's building back better, or whatever the UK call it, as far as the Irish government is concerned. And it's absolutely essential. Just listening to Mark's recitation of all the things that have to be captured, you know, on site nowadays. There's no room for cigarette packets anymore. It has to be all digital, and you know that'll lead to all sorts of efficiencies. And I think once the industry adopts innovation wholesale, you know, other than the frontier companies, I think we'll find much more willingness on the government side to discuss public sector procurement and contracts and all of those issues that really. So I see innovation and procurement and the contract as being two things. If we push on innovation, we get more movement in this area here. And I think that'll really help the relationship between industry and state over the next decade or so.
Thanks, Shane. I really appreciate that. Just conscious of the time, 56 minutes goes by very quickly. I've got some questions that I want to ask, but just before I do so, Mark, I just want to give just a final question to you, really, in terms of what are you seeing in respect to the new contracts that are being tendered? I mean, is there a greater risk and is there more rigour being applied and perhaps future-proofing against the effects of COVID and the transferring of risk? So I just want to get your view from a contractor's perspective, and what are you seeing from the employers, and indeed what are you doing, you know, to your suppliers? Just get a quick snapshot, please, Mark.
Yeah, in very simple terms, yes, there's an awful lot more rigour being applied to that whole issue now. Back to what Niamh said earlier, the force majeure clauses are now, you know, whilst there might have been some grey areas around it, there's no grey area going forward. We all know we're living with this matter now, so we've got to face up with it and deal with it as a risk in our contracts and negotiate it. You know, decide between us. Two parties have got to decide how to deal with it. And if they're going to allocate the risk to, if one party is going to allocate the risk to the other party needs to be prepared to price it and manage it, or find some other compromise. And there's lots of ways that we are seeing that the industry, all parties involved are finding ways to share that risk, all right, and provide some sort of certainty of cost at the same time, if that's a priority for clients. So that's happening. So a lot of time and energy is going into that. We see it every day on all of the new contracts that we're involved in, and indeed down the supply chain. Without question, it's happening down there too. Excellent.
Thanks, Mark. Just a couple of questions before we conclude. This is one regarding, has the panel encountered any employers, whether they be public or private, failing to say whether the project is within the terms of essential exceptions and thus leaving it to the main contractor? So again, Mark, just sticking with you, have you seen any discussions around that, around the word essential, and any confusion that might be concerned around that, please?
Ourselves, no. To be honest with you, no. It's a lot clearer this time. There's thankfully, compared to last time, it's clearly a lot more effort went into it. There's a lot of lessons learned from lockdown 1. So we are as a business, not seeing a big issue there.
Okay, excellent. And just another one then. Are there any risks of liquidated damages being applied against the contractor for delays associated with the period when sites are shut on government orders, albeit a force majeure event? So, Martin, I'll leave that one with you because I think that one's got your name written on it in terms of liquidated damages being applied. What are your thoughts?
Well, fundamentally, yes, unless the contract specifically provides for an extension of time in terms of these events, whether specifically or you can imply them into the force majeure clause. So really, it all depends on what your contract says. But if it's not provided for, and the risk will sit with the contractor if it's not provided for, because the contractor bids on the basis that they can build what they're being asked to build within the restraints they're being asked to build within. So if you haven't provided for it, yes, there is a risk, but then you get to look at ingenious ways of trying to say that it is in the force majeure clause or that it relates to health and safety and come in a different way about it. So, but fundamentally, yes, but you have to look at the contract.
That's great. Thank you, Martin. That just brings us up to 12 o'clock. Just in closing, I mean, obviously from my perspective, I've thoroughly enjoyed the session today. I think personally the industry needs to work together to support the long-term health of our sector by constructively resolving these disputes and working together collaboratively. I know it's easy to say, it's a lot harder to do. So I think the session today has been really useful. I found it useful in terms of understanding what's going on in the Irish market. And I hope you, as the attendees, have all found that interesting as well. I'd like to thank the panelists for attending today. These events don't just happen overnight. They take some preparation to do, and I'd like to thank each and every one of them for giving up their time to do so today. I'd also like to thank Limeslade, Stuart and Annie for hosting it, and obviously for the CIF as well, working in conjunction with us. And just on that, in closing, I believe the CIF have an event coming up called their Outlook Forum, which looks at what is likely to happen in construction in 2021, which takes place on the 28th of January. And I believe it has its own website, which I believe is cifindustry.outlook.com. I think I've got that right, Shane, but let me know if I haven't. On that, as I say, thank you very much indeed, everybody, and I wish you safe and a successful day ahead. Thank you very much. Bye-bye now.
Thanks.
Thank you.